Well, the Supreme Court said no to our emergency appeal asking for a stay of 2 state and local gun bans in Illinois. But that's not all bad news, because there's a very good chance they said no because they're waiting to weigh in on the merits. And they know that your National Association for Gun Rights is about to bring them an official cert appeal so that they can do just that. This is especially true because the Seventh Circuit literally washed their hands of our lawsuit and refused to reconsider the Seventh Circuit panel's anti-gun ruling. That literally leaves us nowhere to go but the Supreme Court on the merits this time. So, there's a lot going on here, and we still have 6 other lawsuits challenging gun bans all across the country that are also moving along. But before I get into all that, please take a moment right now to like this video and subscribe to our channel for updates. And even more importantly, I'm going to ask you to click the link in the pinned comment below and make a generous donation to our legal war chest. Seriously, the backing of gun rights supporters like you is why we are able to go to the Supreme Court and ask them to strike down gun bans nationwide once and for all. So please join us today and help us see this fight home to victory by clicking the link below. All right, so our lawsuit, Bevis versus Naperville, was originally filed a little over a year ago in response to an AR-15 sale ban enacted by Naperville, Illinois. Our friend Rob Bevis is a local gun store owner there in Naperville, and he was literally recruited by the city back in the day to bring his store to Naperville. So you can imagine the betrayal of having that city then turn on you and literally pass an ordinance that could put you out of business. And that is what he was dealing with. So we partnered with Rob to file a lawsuit to stop that. Rob is our individual plaintiff on the lawsuit, and when Illinois passed a statewide assault weapons ban later that year, all we had to do was expand the Naperville lawsuit to also include the state ban. Now, we lost at the district court, so we appealed to the Seventh Circuit. Unfortunately, we drew a 3-judge panel with 2 solidly anti-gun judges. And so the ruling went about like you'd expect. Or maybe it didn't, because while you expect anti-gun judges to rule against the Second Amendment, you don't really expect them to say that AR-15s aren't guns at all as far as the Second Amendment is concerned. But that's exactly what they did say. So, we immediately asked for rehearing at the Seventh Circuit, a process called en banc review, where all 14 judges on the Seventh Circuit would vacate the panel ruling and rehear the case. Now, we asked for that because it was the last lower court box to check before officially appealing to the Supreme Court. And the Supreme Court, since Bruin, has been reluctant to get involved with gun cases that haven't fully gone through that lower court process. For instance, there are 3 gun-related cases that the Supreme Court granted cert to this year. All 3 of those asked for en banc review at the appellate level. 1 case got it, the other 2 were denied. The point is that all 3 of them went through the process of at least asking for it and having the appellate court say no or actually say yes and give them an en banc ruling. By the way, one of those cases is United States versus Rahimi, which challenges federal gun prohibitors based on civil orders where no crime has actually been committed. And the other 2 are Cargill versus Garland, a bump stock case, and NRA versus Volo, which asks if the New York government can put pressure on banks to deny financial services to gun rights organizations like ours. We're filing amicus briefs in all 3 of those cases because any time the nation's highest court is considering the parameters of the Second Amendment, your National Association for Gun Rights is going to be there too to advocate for our members and for the founders' original intent for the Second Amendment. So stay tuned for updates soon on those specific cases and what we're telling the courts in each one. Anyhow, it was important to us to give that Seventh Circuit the opportunity to rehear the case en banc because we believed that that would give us the best chance of having the Supreme Court ultimately take the case. Besides, with where we're at in the Supreme Court calendar, we honestly wouldn't lose any time because even if they were to officially grant cert tomorrow, let's say, we would not have oral arguments on the case before next fall. So it didn't hurt anything timeline-wise. Now, we also took the very unusual step of filing an emergency appeal as well, asking the Supreme Court to block the Illinois and Naperville gun bans immediately while the rest of the case proceeds. To be clear, this was not asking the Supreme Court to overturn the Seventh Circuit's ruling. This appeal wasn't going to affect the underlying case at all. It was just a request for an emergency stay of the law itself. Now, that is a Hail Mary move, and to tell you the truth, we fully expected the court to say no, because they very rarely grant emergency requests. But we owed it to Rob Beavis, our plaintiff, we owed it to our members, and we owed it to the law-abiding gun owners of Illinois to try every possible avenue to stop this tyranny from being enacted. Justice Barrett took the unusual step of actually looking at our case and demanding a response from Illinois on why she should not block the gun bans. And in response, they filed an absolutely bogus response, which we discussed in this video here. So be sure and check that out if you want to hear those fun details. But while we waited, the Seventh Circuit unanimously refused to reconsider the panel ruling that said that AR-15s aren't guns, and they denied us en banc review. Now, there's nowhere to go, literally, but to the Supreme Court on the merits on the case itself. And that may be exactly why the Supreme Court said no to our emergency appeal on Thursday. Their posture, like I said, ever since Bruin, has been that they don't get involved with emergency requests on gun cases until the lower court process has fully played out. And it finally has for this lawsuit. Every single lower court box is checked. So that is the next step. We have 3 months to prepare our official appeal of the actual case to the full Supreme Court, and we will keep you posted on when that's finished and we're getting ready to file. Now, you might be asking what the difference is between the emergency appeal that just got denied and the official appeal that we're about to file. The difference is that the official appeal is asking the Supreme Court to overturn that Seventh Circuit ruling that said that AR-15s aren't guns under the Second Amendment, and that's why they can be banned. The emergency appeal would not have given the Supreme Court the opportunity to do that. That may be why the court said no. But we feel extremely hopeful because we know the Supreme Court is watching our case closely, and they know it's now time to step in or let both the Second Amendment and last year's Bruin ruling be trampled. But y'all, I want to emphasize what a huge place this is to be. Because our goal when we filed our 7 lawsuits across the country against gun and magazine bans was to get a nationwide Supreme Court precedent striking down so-called assault weapons bans once and for all. And a year and a half later, we're about to ask for that ruling. None of us can predict the future, but all I want for Christmas is for Justice Thomas to shred that Seventh Circuit ruling that said that AR-15s aren't guns. Now, what about all our other gun ban lawsuits? I'll tell you that in just a minute, but really quick, we want to tell you about a very exciting upcoming giveaway.
Do you like the idea of winning a very cool pew-pew?
I'll sign up for that.
How about a super cool truck to drive it around in?
I'll sign up for that as well.
Well, then you're in luck. Because we're giving away this truck.
All right, now, let me give you a really brief update on our other 6 cases because we do have some fun updates there as well. We have one other lawsuit that's currently at the appellate level, and that is our Connecticut lawsuit challenging their 2013 assault weapons ban. When that gun ban was passed, we promised our members that we would come back and sue over it. And once we had a legal arm in place and the Bruin ruling for ammo, we did just that. Once again, to no one's surprise, we lost at the district court in yet another outrageous ruling that we discussed in this video. We've appealed that case to the Second Circuit, and it's in the initial briefing stage. Now, also in New England, we have a lawsuit challenging Massachusetts' assault weapons ban, signed into law by then-Governor Mitt Romney. We've been waiting quite a while on the district court to rule on that one, and since the judge called the Second Amendment a suicide pact in oral arguments, we're not exactly expecting that ruling to be favorable. But when we get it, we will appeal that to the First Circuit. Speaking of cases we're waiting on, we challenged the city of Highland Park, Illinois' semi-auto ban as well. That case is stalled at the district court level, but that's probably because the Naperville case is the one that took off. And the judge is simply waiting to see how that one turns out so that he can then apply the precedent to the Highland Park case. We've also sued over Hawaii's AR pistol and magazine bans. And that case was on hold for a while, waiting on the California gun and mag ban cases to be ruled on by Judge Roger Benitez. Those rulings have come down, and the cases are now back at the Ninth Circuit. We have a scheduling conference on our case in January to discuss if we want that lawsuit to go forward or if we're going to wait on what the Ninth Circuit does. That brings us back to Colorado, where your National Association for Gun Rights is located. We have two lawsuits here, one that challenges the Colorado magazine ban, and the other challenges 4 local AR-15 bans also in Colorado. These cases, both of them, have gone through the full discovery process, and we've officially asked for summary judgment. That means that we want to skip a trial because this is just about whether these laws violate the Constitution. There's no determination of facts that needs to happen, which is what the trial process is for. So we asked the judges in those 2 cases to just skip that phase and give us rulings striking down the laws. We are waiting for the rulings in both of those cases. But we did have one annoying hiccup happen in our magazine ban case. So our argument is that since standard capacity magazines are in common use, you cannot ban them under Supreme Court precedent. So the leftist attorneys actually got the judge, a Biden appointee, to throw out our expert witness on the number of mags in circulation. Now, just to put this in perspective, this is like arguing in court that birds are very common, and then having the other side go, but how do you know there are a lot of birds in the sky? The fact that we can all see them is just anecdotal evidence, and we can't really rely on that. So we have to go find somebody to count the birds. Fortunately, the court did give us time to find another expert witness to speak to the number of magazines in circulation, so that's what our team's working on right now. So that is the status of our gun ban litigation program. As you can see, it's a lot of exciting stuff, and we would ask you to join with us and help us fight these gun bans by clicking the link below and making a generous contribution to our legal war chest. Also, if you have any questions about our lawsuits or Second Amendment litigation in general, drop them in the comments below, and we'll try to answer those in a future video. Thank you so much for your support, and stay tuned for further updates.